Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, right? And basically in fundamental rights, we have done with introduction and basically we have been discussed upon the features. Now, what we are going to see that basically in the previous lecture, we had started the first right, which is the right to equality. Okay. And it is compared two things, or you can say but it comprises, not compares. The first is equality before law and second one is equal protection of laws. So Article 14 says that the state shall not deny any person equality before the law or the equal protection of the law within the territory of India. It means that if we talk about law and its jurisdiction, then it equally applies to all the persons living in this country. This provision confers rights on all persons, whether they are citizens or the foreigners. It means that it is not exclusive fundamental rights, but it is an ordinary fundamental rights. It means that it is available for both, whether they are the citizens of this country and whether they are not the citizen of this country. Moreover, the word person is not only includes to the human being, or living beings, human being or living ones. Basically, it includes the legal persons also, like the statutory corporations, like the companies, okay, like the registered societies or any other type of legal person. They all are included here. Now, if we take it further, so we will notice the concept of equality before law is of the British origin, while the concept of equal protection of law has been taken from the American Constitution. So basically, when we were discussing upon the salient features of our Constitution, one thing I had told you there that basically the two constitutions, like the British Constitution and then the American Constitution, these two constitutions have their more impact on our constitution. All right. So basically, if we talk about it, so what we had seen that Article 14 or the right to equality, which comprise two things, right? The equality before law and the equal protection of law. Even these two concepts belongs to these constitutions. Like equality before law belongs to the British Constitution, while the equal protection of law belongs to American Constitution. All right. So if we talk about the first concept, which is the equality before law, okay, it connotes the absence of any special privileges in favor of any person. Okay, like if we take it, so basically we have to go to the medieval Europe. Okay, in medieval Europe, basically there was a system that developed as a system of class, which means that there are first the king or ruler class. Okay, then comes the nobles, nobles class, and then comes the normal people. Okay, so basically whatsoever the rules or acts drafted by the kings or the rulers for their territory, these laws and acts having the different implications on the nobles and on the normal people. Like nobles always have some special privileges by which they could be saved, while the normal people did not have any special privileges. So that's why the laws or acts directly implied on them. Okay. So first thing in the equality before law was done like the absence of any special provisions in the favor of any person. It means that doesn't matter who are the person standing front. Okay. There will be no special privileges will be granted to that person. Thereafter, the equal subjection of person to the ordinary law of the land administered by the ordinary law courts. It means that each and every persons who are living here will have the equal subjection of any ordinary law administered by the ordinary law courts. Okay, and no person, whether he is rich or poor, high or low, official or unofficial, is above the law. Okay, it means that, like if we talk about the previous one, the king or the ruler class who were ruling the area, all right, they had exempted from the laws or acts enacted. Okay, and this system is not so prevalent nowadays. If we talk about this, so basically you can say the ruling prime minister, okay, and the president and all, they are not above the law. However, due to some reasons, they have the privileges, but their equality is as per the par of the normal citizens of this country. Okay, so that is the concept of the equality before law. No special provisions, equal subjection, and everyone is equal before the law. The second concept, on the other hand, connotes like the equality of treatment under equal circumstances, both in the privileges conferred and the liabilities imposed by the law. It means, suppose if some law contains some provisions, all right, so these provisions will be equally, you can say, conferred on the persons in the equal circumstances. Okay, it means that not only the law, even the provisions of the law will be implied on the person on the equality basis. The similar application of the same laws to all persons who are similarly situated. It means that the law will be applicable on each and everyone in the same manner as it applicables on the others. The like should be treated alike without any discrimination. All right. Thus, the former is the negative concept, while the later is a positive concept. Okay. However, both of them aim at establishing equality of legal status, opportunity, and justice. Okay. So basically, the Supreme Court held that where equals and equals are treated differently, Article 14 does not apply. It means Article 14 having the similar applications that all the ones are equal for law or equal before law. Basically, you can say equal before law. All right. While the Article 14 forbids the class legislation, permits reasonable classification of persons, objects, and the transactions by the law. But the classification should not be arbitrary, artificial, or evasive. Okay? It means that it must be rational and equal. Rather, it should be based on an intelligible differential and substantiable distinction. It means that if there is any differential and a distinction which is required to be made in some specific conditions. Okay, then these must be intelligible and substantial, or you can say rational or equal. Rule of law, the concept of equality before law is an element of the concept of rule of law. Okay, and basically that was propounded by A.V. Dicey, who was a British jurist. All right, and his concept has the following three elements or aspects in the name of rule of law. First is absence of arbitrary power, that is, no man can be punished except for a breach of law. It means that the authorities do not having the right to punish anyone until or unless the person who got punished has breached any law. All right. Thereafter, equality before the law, that is equal subjection of all citizens irrespective of their rich or poor status, high or low status, official or non-official status. Okay, to the ordinary law of the land administered by the ordinary law courts. Thereafter, the primacy of the rights of the individual, that is, the constitution is the result of the rights of individual as defined and enforced by the courts of law, rather than the constitution being the source of the individual rights. Okay, like we know, if we talk about it, so basically in Britain there is a unwritten constitution, right? Okay, that's why what happened, like whatever the interpretation of the constitution done by the courts, okay, that's assigned the rights of the individuals, okay, and that enforced by the court of law. But if we talk about the written constitution, so the written constitutions are basically the source of the individual rights because everything is well defined there. All right. So that's why he said that the primacy of rights of the individuals, that is constitution. And the constitution is basically framed by the rights of individuals, which were defined and enforced by the courts of law. Not the constitution is the source from which the rights of individual could be derived. Okay. So what was the reason behind it? I have told. The first and the second elements are applicable to the Indian system and not the third one. It means that in Indian system, no one is punished until the breach of law. Second one, there is a equal subjection to all in India. But if we talk about the third one, so because the India having the written constitution and not the unwritten constitution, so that's why the third one is not applicable to India. So in the Indian system, the constitution is the source of the individual rights. It means that the individual rights are not depend upon the interpretation and the enforcement of the courts, but they are defined clearly in constitution. All right. So the Supreme Court held that the rule of law as embodied in the Article 14 is a basic feature of the constitution. Okay. And thus it could not be amended. Okay. Like written down here. Exception to the equality. The rule of equality before law is not absolute, and there are constitutional and the other exceptions to it, as I have told you. Like basically some of the official members of this country, all right, are having some kind of constitutional privileges, sorry. Okay. And these are mentioned below. The first, the President of India and the Governor of the states enjoy the following immunities under the Article 361. The President of India is the head of the nation, and the Governor of the states is the head of the respective states. All right. So the first thing we could see here is the president or the governor is not answerable to any court the exercise and performance of the powers and duties of his office. Like if the president or the governor has done something under the powers and the duties conferred on them by their office, so he or she, whether he's a president or the governor, they could not be answerable to any court for the action. Thereafter, no criminal proceedings shall be instituted or continued you can say against the president or the governor in any court during his term of office. So if someone, suppose from 2001 to 2005 or 6 for the tenure of 5 years, okay, if someone was the president or the governor, so during this term period or during their office term, no criminal proceedings could be initiated or continued against them. All right. So, as long as they will remain in the office, they will be exempted from the criminal proceedings. No process for the arrest or imprisonment of the president or governor shall be issued from any court during his term of office. It means that no court in this country could pass the orders for the arrest or the imprisonment of the president or the governors when they are in their office, and you can say during their term of office. Thereafter, no civil proceedings against the president or governors could be instituted during his term of office in any court in respect of the act done by him in his personal capacity, whether before or he entered upon his office, until the expiration of 2 months after notice has been delivered to him. All right. So that's a thing. Thereafter, another point we could see here is that no person shall be liable to any civil or the criminal proceedings in court in respect of the publication in a newspaper, by radio or television of a substantial to report of any proceedings of either House of Parliament or either House of the Legislature of the state, Article 361A. Like if someone publishes the you can say substantially to reports of the proceedings happened in either House of the Parliament or the legislatures of the state through the mediums by radio, television, or newspaper. So the person could not be convicted in any civil or the criminal proceedings in any court of law under the Article 361A. Thereafter, no member of Parliament shall be liable to any proceedings in court in respect of anything said or any vote given by him in Parliament or any committee thereof. Article 105. Okay. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof. Article 194. All right. So 105 is basically applicable for the member of Parliament, while the 194 is applicable for the member of legislatures. All right. Thereafter, another thing here is the Article 31C. So basically, the Article 31C is the exception to the Article 14. How? So basically, it provides that the laws which have been made by the state for the implementing of director principles contained in Clause B or Clause C of Article 39, they cannot be challenged on the grounds that they are violative of Article 14. Okay, like you can say, if the government passed any resolution, okay, regarding the Clause B and Clause C of Article 39, which is a part of director principles, and to be very, very specific, socialistic, classification of directive principles. Okay, so these provisions could not be challenged on the ground that they are violative of Article 14. So basically, the Supreme Court held that where the Article 31C comes in, Article 14 goes out. Why? Because 31C is the total exception to the Article 14. The foreign sovereigns, rulers, ambassadors, and diplomats enjoy immunity from criminal and the civil proceedings. It means that if there is any ambassador and diplomat of the foreign countries India friends with, if they committed any criminal and the civil crime, then no criminal and the civil proceedings could be registered against them. And this concept is broadly known as the diplomatic immunity. Okay. So the UNO, which stands for the United Nations organizations. So the UNO and its agencies basically also enjoy the diplomatic immunity. Like if the UNO members and the agents of them commits any criminal or the civil crime, so no criminal and the civil proceedings could be filed against them. Okay. Thereafter, another one is the prohibition of discrimination on the grounds, on certain grounds, which is Article 15. Like, no person could be discriminated on certain grounds by the government and by the normal people. So basically, the Article 15 provides that the state shall not discriminate against any citizens on grounds only of religion, race, caste, sex or gender, or place of birth. So basically, the government is restricted or prohibited to discriminate between the people on the basis of their religion, on the basis of their race, on the basis of their caste, on the basis of their sex or gender, or on the basis of their place of birth. The two crucial words in these provisions are discrimination and only. Okay. So what are these? So the word discrimination basically means to make an adverse distinction between regard to. Okay. Or to distinguish unfavorably from others. Alright. Discrimination means to differentiate ones. Alright. So that's the meaning of it. The use of word only connotes that discrimination on the grounds is not prohibited. Okay. It means that only because of their religion, only because of their race, only because of their caste, only because of their gender or sex, on the place of their place of birth, no discrimination could be committed by the state. All right. So, the second provision of Article 15 states that no citizen shall be subjected to any disability, liability, restrictions or conditions on ground only of their religion, their race, their caste, their gender, their place of birth, with regard to access to the shops, public restaurants, hotels, and the places of public entertainment, or to use the wells, tanks, bathing huts, roads, and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. So basically, if anything is for the public usage, okay, then the entry of the person could not be restricted because of their religion, because of their race, because of their caste, because of their gender, or the places of birth. This provision prohibits discrimination both by the states and the private individuals. Okay. But here is a one thing which we could see, like when we talk about the state as per the definition of Article 13, stands for the central government and its authorities, the state government and their authorities, the local government and their authorities, and any other department established by the government. And if there is any agreement signed between them, then the private organizations are also considered under the state term. Okay. So the state is only restricted to discriminate on the certain grounds, and the grounds we had seen. Okay. But the private individuals are not allowed to do it altogether. Thereafter, there are 4 exceptions to this general rule of non-discrimination. The first exception is the state is permitted to make any special provision for the women and children. For example, reservation of seats for women in local bodies or the provision of free education for children. The second exception to this case is that the state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens or for scheduled caste and the scheduled tribes. For example, there is a reservation of seats or the free concession in the public educational institutions. Remember, that is in generally basically for the public funded institutions. All right. Part C is the state is empowered to make any special provision for the advancement of any socially and educationally backward classes of citizens, for the scheduled caste and the scheduled tribes, regarding their admission to the educational institutions, including the private educational institutions, whether aided or unaided by the state, except the minority educational institutions. Okay, but here are rights for these institutions so that they could challenge the provisions in the court. The state is empowered to make any special provision for the advancement of any economically weaker sections of citizen. Further, the state is allowed to make a provision for the reservation up to 10% of seats for such sections in admissions to the educational institutions, including the private educational institutions, whether they are aided or unaided by the state governments, except the minority educational institutions because they are allowed to manage the institutions by their own. This reservation up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker sections, which is also known as EWS, would be notified by the state regarding the reservation by the official gazette from time to time on the basis of the family income and other indicators of economic disadvantage as the state considers. Okay. So basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.